2023. We have set this day and agreed on it when we met on the 11th of August. But also this day, even without looking at the date, was etched into our terms of reference that when we're done with our work, we'll have a day when we look into and consider the final adoption of our report. So today's meeting's main focus is that main item. But we do have other items that we're going to consider before that and after. As the agenda would have been sent to you, we will look into the correspondence that might also be speaking to the main item of the adoption of the report. At the end, we'll conclude with our minutes. But before I do that, I'm going to ask Thembi Nkosi to just share with us what apologies we have.
Good afternoon, Chairperson. Good afternoon, members. Thank you, Chair. We have apologies from Dr. Gondwe, an apology from Mr. Heron, and Ms. Dana will be joining us later, Chair. That's all I have before me. Thank you very much.
Thank you, Honorable Gondwe, Heron, and Honorable Dana. An apology to join the meeting late. Thank you for that. Do we accept those apologies, honorable members?
Accepted, Chair.
Thank you. No objections. We proceed. Maybe before I ask Thembi Nkosi or Fatima just to lay down the correspondence that we have received, which has been sent to you, just from my side to indicate that on the 11th of August, after we finalize the adoption of our draft report en route to the suspended public protector, on the same day, the report would have been sent to the public protector for her comments, and she would have been given a deadline of the 21st, which is yesterday. Today is the 22nd, and I got it wrong when I was saying that before. And so yesterday would have been the last date expected of the public protector to give us comments. We will hear from the correspondence. I'm going to ask Thembi Nkosi to just and Fatima to just summarize the correspondence, and then I will then speak thereafter and then invite the members for the discussion.
Thank you, Chairperson. I think Chairman is just to concur that there's been communication between the committee and the office of the State Attorney, as well as Advocate Mkhwebane, and also Motswaneng Bill attorneys. But Fatima, Chair, will take members through the contents of that correspondence. Thank you very much.
Thank you, Mr. Ngoma. Ms. Ibrahim.
Good afternoon, Chairperson and members. Chair, I'll start with the correspondence, or I'll pick up at least from after the last meeting of the committee. So after the committee met that evening, the Secretariat then sent the Public Protector a copy of the draft report as adopted and indicated, as you've said, that she had until yesterday to make comments, so a period of 10 days. On the 14th of August, there was a letter from the chairperson to the State Attorney, Mr. Chawe, and this was in response to a letter that Advocate Mkhwebane had sent on the 11th of August. And members will recall that letter because they deliberated on the contents thereof in respect of her request for an extension of time. And there, the chairperson reiterated that the onus has always been and remains on Advocate Mkhwebane to do the necessary to secure her legal representation, and that the committee had not impeded her in any respect thereof. And the chair reiterated his position as the chair, that despite the 2 recusal applications that were submitted against the chair, as chairperson, his job is to ensure that the process is brought to finality, and of course to balance the requirements of fairness to the PP on the one hand, but also the obligations of the committee to fulfill its constitutional obligations and public interests on the other. She was informed that the committee had deliberated on her letter and was resolute that it had not prevented her from accessing or availing her rights to legal representation, and therefore the application or request for postponement was not agreed to. Chairperson, on 14th of August, there was a letter from the PP to the State Attorney, but that wherein the Secretariat was copied and you as Chairperson as well. She raised the legal implications of the withdrawal of Chane and the fact that she is now without legal representation of either attorneys and or counsel, and notes that in respect of the merits of the inquiry, she's been without legal representation since 31 March 2023, which would have been the last day in which she gave oral evidence. And she noted in that letter that she had telephonically requested the State Attorney to provide her with a list of the attorneys that are on the PPSA panel of attorneys so that she could then choose new attorneys of record. Chairperson, between 14th of August and 20th of August, there would have been that process for the appointment of new attorneys, or at least we were only informed on the 20th of August, where we received a letter from Motswaneng Bill attorneys informing us that they are the PP's new attorneys of record. That was sent on the 20th of August in the evening, and that letter noted that they will meet with their client, being the PP, in the next 72 hours, but by no later than Wednesday, the 23rd, which would be tomorrow. Thereafter, they would brief counsel and make contact with the evidence leaders and Chani to access the record, and that they would provide weekly updates in the form of a progress report to the committee and also list any issues of concern that they may have. And they noted the intention to ask counsel, once appointed, to draft a status quo memo and to advise, subject to approval by State Attorney or the PPSA, for them to obtain same. They also then said that they estimate that they can only meaningfully participate in the next, and I'm quoting here, Chair, in the next couple of weeks or so, depending on the nature of the record and the extent of issues arising. So they request that they be granted the necessary space to fulfill the obligations, and they state that obviously the deadline for the PP to submit representations on the draft report must fall away, even assuming that that is the next step in the process, which is, and their letter says, possible to say at this stage. They obviously mean to say impossible to say at this stage. So in short, that letter is indicating that they intend to brief counsel, but that they would still require some time to familiarize themselves with the record and to get some direction from counsel as to the way forward. And that way forward may or may not be comments on the draft report. It may take us back to something else that the letter obviously doesn't go into detail, because the attorneys would still wait on counsel to do that status quo report for them. Chair, the Secretariat did acknowledge receipt of that letter yesterday and indicated that it would be tabled before the committee today so that the committee can deliberate and make a decision on that request in that letter, that they be afforded more time. Chair, that is the update on the correspondence to date. Thank you.
Thank you, Ms. Ibrahim, and thank you, Mr. Ngoma. Honorable members, I'm not intending to waste any time. The correspondence that has just been summarized for you, you would have received that correspondence. You would have read it. It was merely a summary that was being done. And therefore, you please acknowledge that in your contributions. I am actually now, with that in mind, inviting members for their own contributions in relation to the main purpose of this meeting, which is about this committee considering the final report. I must just indicate that what both Mr. Ngoma and Ms. Ibrahim have taken us through, as we sit here, we have no comments or submission from the suspended public protector on the report itself. What we have is that correspondence that you have just listened to. May I invite you, honorable members, to make your contributions. Honorable Nkosi, to be followed by Honorable Dagude, in that order. Honorable Nkosi, your platform is yours. Yep. You can switch off your camera so that we get proper you get proper network. Honorable Nkosi, we can't hear you. Just switch off your camera.
Chair, I acknowledge the summary.
Just start again. We missed you there. Just switch off your camera as well.
Chair, the camera is off.
Okay, go ahead. Go ahead.
Thanks, Chair. I'm saying I acknowledge the summary given by Ms. Ibrahim. I've gone through the correspondence from yourself and from the new attorneys. Chair, I think the first thing to note is that for our purposes, we have always maintained that the public protector has legal representation. It is a responsibility to brief legal representation. Two, that in the correspondence, it's clear that were we to consider it positively, it will impact on our own internal deadlines and our obligations to the National Assembly in terms of reporting within reasonable time. I think we've taken too long on this process. And three, Chair, it does look like the attorneys know that they can brief, they can meet with and receive instructions from the PP within 72 hours, but they don't know how long it's going to take them to go through the record. And they're speaking about a few weeks, after which they may come back to us and indicate that this is a step that they are taking, they are responding or not responding. I think my considered future is that in view of the fact that we have an obligation to report on this matter, that reasonably so, we have granted the PP the opportunity to comment on the report. She has always had legal representation. The committee never impeded her from utilizing legal representation of her choice. But also that I think, I don't think that the PP acknowledges and even understands the severity of the charges that she faces and the implication for herself and that office. And on that basis, Chair, I think the circumstances and the deadlines that we have do not allow us to positively consider the request from the attorneys. My proposal, Chair, is that we acknowledge receipt and explain the process at which we are, and the circumstances, but politely indicates that we have an obligation to report, and therefore we will proceed to consider the report for additional time at this late stage. The PP's term of office expires in October, and this committee should by then have reported to the National Assembly, and the National Assembly should have taken a decision. Either to accept or reject this report. Thank you.
Thank you, Honorable Nkosi. Your line was breaking a bit there throughout, but we did pick up what you're saying. Honorable Dlagude.
Thank you very much, Honorable Chairperson. Good afternoon to you and everyone on the platform. Honorable Chair, I want to concur with Honorable Nkosi on his sentiments, and also to add that, Honorable Chair, as this committee, we don't have an open-ended mandate or time to deal with this inquiry. So time is of essence for us. And also to mention that, Honorable Chair, the suspended PP was given enough time to get legal representation and all the processes that we've been through as this committee with regard to assisting her as well to source funds for her to utilize in order to get legal representation. So I would say we have spent more time in this regard and wasted more time, again, with a view of ensuring that we do our work diligently and also in a fair manner. We conduct this inquiry in a fair manner. So from where we are now, we know, Honorable Chair, that Chane attorneys were supposed to brief a senior counsel. They were given that time after the recovery of Mr. Chane. As we all know that he was once in hospital, so they were given that opportunity to do their work. But their main focus was administrative, writing letters to and from the committee. So that is what they mainly did in this regard. So with us, we have come to a point where we are supposed to adopt our report and the report be taken to the National Assembly where a decision will be taken. So we are at that stage now, Honorable Chair. We have given the PP the Audi that she needed. We gave her the Audi and also the courtesy to go through the draft report and react to it. Unfortunately, that opportunity, the suspended PP missed those opportunities. So where we are now, I would suggest that we note the correspondences that we received as a committee and also adopt this report. Thank you, Chair.
Thank you, Honorable Dlagude. Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, I would have liked the Public Protector to comment on our report so that I can consider supporting or not supporting some of her representations. So it is very disappointing that I don't have an opportunity to do so. Having said that, Honorable Chair, if the Public Protector, for example, had to comment on the offences relating to labour relations, industrial relations, or HR, where the committee found that she was at fault, and she objected to the findings of the committee. I would have supported her because such matters, employment-related matters, must be dealt with by the CCMA, and that is the forum where such matters are decided. And I think it is sad that our committee spend too much time on matters where there is another forum to deal with. So the complaints against the public protector with regard to IR or HR disciplinary matters, for me, is mute, because those individuals involved had the opportunity to go to the CCMA, to go for arbitration, and that is where those matters should have been settled. Having said that, Honourable Chair, you know my position, and I don't support the impeachment of the public protector. So I want to make a last desperate representation to the committee that we should consider a lesser penalty. I am not sure whether the public protector Act and related acts allows this committee to consider a lesser penalty after Parliament has asked us to look at impeachment. So I'm not sure whether that is whether there's any discretion, because it is a part of natural justice that one must always look at mitigating circumstances. The mitigating circumstances, which I hope the public protector would have put on the table, was the fact that there are thousands of cases where she did well. Number two is that after that she came in cracking the whip, which was needed because a lot of cases was unnecessarily delayed and took too long. So she acted like a father and not a mother, if you understand what I mean. And also the fact that the Office of a Public Protector was plagued with bad audits, and she restored the dignity of this office 3 times in a row, I think, where there was unqualified audit. Surely those are mitigating circumstances, and shouldn't we go to Parliament to state that our position was to call for the impeachment, but after taking the representations of the public protector into account, which he didn't do, and which I'm trying to do. I mean, I can't speak for her, but I would have expected those matters to be put before the committee so that we consider a lesser penalty than impeachment. And I'm not sure what that penalty should be. Lastly, Honourable Chair, I have to, seeing that this is our last word on the matter, I have to say that the Public Protector's Office is a Section 9 office. It is not a specialist court in terms of the Superior Courts Act. There are checks and balances giving the office certain leeway, certain discretion, certain informality to speed up matters. And the checks and balance is that when the Section 9 office, like the Public Protector's Office, makes determinations, which is not the high standards which a silk like we have would present to this committee, the checks and balances is that any person who feels aggrieved at the determination of a public protector has direct access to the High Court. When it comes to, for example, something similar in my mind, the way the public protector should have acted is like the CCMA. There you only have access to the High Court under special circumstances. But in the case of the public protector, there are no restrictions. So I would like to conclude to say that I am very concerned that the objective of the Constitution for Section 9 structures is going to be defeated, because this inquiry has used the highest standards that you can find, even equal to the Constitutional Court, to make determination. Now, I suppose there's nothing wrong with that, but that is not in the true spirit of why the Constitution provides for Section 9 committees. Thank you very much for giving me this opportunity, Honourable Chair.
Thank you, Honourable Hendricks, for your contribution. I now recognize Honourable Mailam.
Thank you, Chairperson. Good afternoon to members. Chairperson, let me start by saying that this committee has been more than reasonable in its dealings with the Public Protector, both in terms of the time that we have allotted to affording her cross-examination of witnesses, to presenting her own evidence, to pontificating and expounding on various opinions and matters. And we've also been more than reasonable in assisting her with regard to the financial support that she found necessary to procure her legal representation. Chairperson, our parliamentary processes cannot be held ransom to or dictated to by a person or persons hell-bent on running out the clock. We have to deal with things timeously and speedily, and we have to ensure that our parliamentary inquiries are dealt with effectively and efficiently. And all that's happened during the course of this inquiry has been for Advocate Mpofu and Advocate Mkhwebane to play for time. So I think we need to factor that into our deliberations. We have repeatedly said that Advocate Mpofu is intimately familiar with the merits of this case, and that
you want to say Advocate Mkhwebane?
No, Chair, I'm saying Advocate Mpofu, her legal representative.
Okay. Oh, sorry. Sorry. My apology.
That Advocate Mpofu is intimately familiar with the merits of this matter, and that it is therefore unnecessary for the attorneys to spend weeks and weeks and weeks familiarizing themselves with the matter, when essentially they need to get him on brief and dealing with the merits that he already is well aware of. Nothing this committee has done has in any way impeded or hindered Advocate Mkhwebane's ability to brief her legal assistance. We cannot be accused of having prevented her from presenting her case or from contesting any evidence. The lack of the response from the Public Protector cannot be grounds for this committee's report to be dismissed. Now, I want to address a couple of issues that Honourable Hendricks has just raised. The first is this. He said that HR matters should be dealt with in the CCMA. However, Chairperson, HR matters are not beyond the purview of this committee, because our mandate is to investigate the possibility of misconduct or incapacity or incompetence on the part of the Public Protector. And if there has been any such misconduct, incapacity or incompetence, to then make a finding of that nature. It's not outside the scope of the CCMA. Those matters still have to be dealt with in the CCMA and the Labour Court and the like. However, we are not looking at the merits of those issues. We are looking at the conduct of the Public Protector. The second issue that I want to take exception with is his plea for an alternative sanction. Chairperson, the Constitution is the highest law in the land. It supersedes the Public Protector Act. It supersedes the Superior Courts Act. It is the bedrock of all our other laws. And Section 194 of the Constitution talks specifically to the removal from office of the Public Protector. So we don't have an option here. Our option is to find her guilty and therefore warranting removal, or not guilty and therefore not warranting removal. This committee has gone through all the evidence. We've gone through it very, very carefully and judiciously. We've looked at it in great detail. And therefore, Chairperson, I want to propose that we adopt the final report of this committee. Thank you, Chair.
Thank you, Honorable Milam, for your contribution. I now recognize Honorable Siwela.
Thank you, Chairperson. Greetings to my colleagues. Chair, I won't repeat what other honorable members have said, but rather to say that I'm highly disappointed, like Honorable Hendricks, because I was expecting that we'll get the response from the public protector. According to me, this committee has been fair enough. We have spent more time, we have been patient, and we gave the PP an opportunity to can and look for her representatives, which has been granted by this committee. So the issue of the Anthony Mr. Chano, I agree with those other honorable members that his role was to facilitate administratively, to brief the SC, and the SC, which is familiar with this matter for a year. So, Chair, we're not going back. We're moving forward. The PP was given enough time. The PP decided not to use that opportunity. Yes, of course, we note the correspondence, as others have said, but what we need to do today is to adopt the report based on three things, as other honorable members has indicated, whether we are finding her guilty or not. So I think our decision still stands. The public protector has failed herself. She has failed herself to do herself favor by not responding to our report. So we don't have any option rather than to stick to our decision. Our option is to adopt the report and forward it to the National Assembly. We are disappointed, Chair, but we don't know what is the motive behind. We have spent more time on this matter. I believe we need to close this chapter. Thank you.
Thank you, Honorable Siwela. I now recognize Honorable Dana.
Thank you, Chairperson. Chair, I think we follow due process, what is expected of us, and I second Honorable Milam's proposal that we accept the report. Thank you, Chair.
Thank you, Honorable Dana. Honorable Maotwe.
No, thank you, Chair. Chair, I think you know our position as far as the report itself is concerned. But I want to remind everybody who seems to have forgotten that the PP has not had a legal rep effectively from the end of March. So everything that happened between March and now happened without the PP's legal team. We've got correspondence from attorneys that were appointed. They went to hospital, they were sick, they came back. They said they can't continue because of the conduct and the manner in which they were handled. They withdrew. The state attorney came upon realization that there were concerns about conflict of interest. They withdrew. And only last week, the PP got to get the legal representation sorted. And the letters are before us. So I don't understand when we come here and we say we're disappointed that the PP has not responded. How is she going to respond when she highlighted that she doesn't have the legal rep? The legal rep is now here, Motweni, attorneys. They're saying to you and all of us, Chair, give us some time to go through the correspondence. Give us some time to go through everything to familiarize ourselves with this so that we can know what direction we're taking. So I'm not sure if we're expecting that they were supposed to respond to a report that they don't have the background of. I think, Chair, we continue to be so unreasonable to the PP. We are in a haste to really close this matter and disregard everything else that is before us. We said it previously, Chair, that
You have failed all the tests of fairness in this manner. So right now, today, you are caught between a rock and a hard place, because if you say, let's afford them the opportunity, you are effectively saying, we must start from scratch, from where we left off in March. So that is what we are sitting with. You might not say it, but that is the implication, because if you grant them the time now, you are effectively agreeing that everything that happened between March and now should be erased and we start from scratch, because the reality is that we have not had the participation of the legal rep of the PP from March until now. So this meeting is just called to rubber stamp what has already been pre-concluded, that no, we must continue. When in your introduction, Chair, you said the date of today was already on the calendar. It's true. So, but that date when it was set, Chair, there were not these circumstances that we find ourselves in. Unless if you are saying it was all planned, that the acting PP will say there's no money and this is how we're going to drag it and all that. Because that's the only explanation one can have, to say, yes, all of us, we've got the intended date to finish the matter, but we don't know, we can't preempt what's going to happen in this journey. And it has proven itself that indeed, we could not have anticipated that there's going to be these delays, which were not caused by the PP to start with. So colleagues, the PP could not, and I'm not her advocate, I'm not her ambassador, but I'm just looking at the fairness of the process. If you were to take this matter to court to test the fairness, there's not a chance of us winning it just on the basis of fairness. We have not been fair, colleagues, and we continue not to be fair. Now we've rushed this process to come to the end, and we realize that we can't do anything, we can't maneuver. But our position as the EFF, and it must be recorded, is that today we are saying afford the legal rep of the PP to familiarize themselves and to come and represent the PP in this committee. We can't preempt what they're going to say. They are fair to say we don't know the magnitude of this matter, Chairperson. The PP has not responded fully to the charges, but we have made already the findings ourselves. It is very unfair, and we stand with our position. But Chair, for this purpose of the meeting, we are saying, let's afford them the opportunity to go through. Let's not rush the process on the basis that we've got a deadline, which was set prior to us finding ourselves in this situation. That will be our submission as the EFF Chair. Thank you.
Thank you, Honorable Maotwe, for your contribution. Honorable Mkhwebane, you are recognized.
Thank you very much, Chairperson and colleagues. I would like to concur on what the previous speaker alluded to. As a committee, we know exactly why such delays from the PP side. We were clear, and the report was given of the problems that the PP is encountering. If OPP now has got a legal team, there is no way that we can rush. Let's give her an opportunity. Let's give her an ear to hear. But let us set time frames from a legal team when they are supposed to submit what we are expected from them. So it's my view that let's give her, if we are saying we are fair enough for OPP, let us afford her and then put time frames, because it seems as if she's ready now, knowing exactly the problems she was experiencing. Thank you very much, Chairperson.
Thank you, Honorable Mkhwebane, for your contribution. I now recognize Honorable Maneli.
Thank you, Honorable Chair. Greetings to members and everyone else on the platform. Chair, let me start on the part of the correspondence and note the correspondence received. I think other members before me, in particular Honorable Kosi and Honorable Dlakude, would have spoken to the point about the time that we really do not have, Honorable Chair, at this stage of the inquiry. many weeks to go through and determine whether you proceed or not. For that reason, indeed, it should not be acceded to. But Chair, I just want to picture so that those of us who have been attending religiously to proceedings of the committee would remember this. Chair, right as we have started, there's always been fairness. There's always been contest about inherent bias and all that. And these were clarified as we're going through the journey. Whether it's a matter that gets to a court situation, like in the first recusal application, and those matters get clarified. And then we proceed. Chair, even when there were problems about what gets to be budgeted and what gets to be used, which is over expenditure, if I were to put it bluntly in that way, because once you move from 0 to 30, and those costs in the main were not about the responses to the inquiry, but other matters that seek to see any loophole that can exist to stop them. And the resources got depleted. I think, again, Chair, out of fairness, it is the reason that the committee led by you, and for some of us, you would know, Chair, we're on record, that it was really matters that are just beyond the committee, which should have been handled by the PPSA, but agreed that from a point of fairness, those resources must be acquired. And when I say acquired, I'm starting from the point of invoices not paid, and that given as a reason not to proceed. And those got sorted. And you get to the resources that are depleted by end of March, still get to, again, another approach led by yourself to ensure that there's additional resources, and that's where the 4 million comes from. And that the PP can be assisted legally, Chair, on matters that are before this committee. But it doesn't end there, Chair. We must put the point that we have, Chairperson, right in the beginning, asked questions as members of the committee. And again, as I say, from a point of fairness, we are advised that the PP was not yet answering to questions, and those would be forwarded and be answered later on. And those have not been answered, Chair. But the PP, I must appreciate, Chair, that the PP has helped the committee in response to all other witnesses. Like I said, I would not repeat what other members would have said. But the PP gave us Part A and Part B response in writing in a form of statement that's before this committee. And this committee then gave an opportunity for oral evidence without undermining the validity of what the PP has put before this inquiry in writing. And of course, we have listened partially to oral evidence given. But it does not remove the fact that the PP has responded to the charges as per what is before us, Chair. I'm raising this so that there's no assumption that we are making decisions without considering what the PP would say to such charge. Chair, even when it was difficult to proceed with all the legal issues that get sorted, and I'm going to come to the legal, Chair, briefly. But I want to still come from a point of giving the PP again an opportunity to speak. All members who responded to the call of the decision of this committee to allow members to present questions that the PP will respond to did so, Honorable Chair. But on record, Chair, there's not been responses to those questions, which was also another opportunity, at least to hear the side of the PP in contesting or agreeing with the things that would be asking based on evidence that has been put before the committee. Chair, in that score, I come then to the part of the appointment of this, the legal people. I want to start from a point, Chair, that I think one appreciated at the time when the PP said she would want to have Advocate Mpofu to continue to be the senior counsel of her choice. As she would be also looking at the appointment of other attorneys through that engagement that she was to have with the PPSA. And I'm saying, Chair, as time moved, at least it is on record before this committee that the PP reduced it to writing that she wanted an attorney of her choice, or at least the state law advisor offices helping her in that score. So this thing that the state law advisor has just imposed himself or herself, knowingly that there's conflict of interest, is misrepresentation of facts before us. Because it is the PP who introduced that aspect in case one doesn't work. Of course, it should be surprising then that at the time that that action is implemented, then the conflict of interest is questioned at that time. But be it as it may be, then the attorneys Chani were appointed. The other, it's history that we're reminded of a deathbed and all that, Chair. We've spoken to this before. But the point I want to bring to this, Chair, is that if you look at the date of appointment and the date of withdrawal, that's almost over a month. Almost the same time that we would have asked for to go through documentation. And as other members would have said, but the focus got to be something else. It was administrative matters of writing letters. And I'm sure at some point we would know what that costed the taxpayer. But for me, of interest is that with this understanding I have brought before of even the senior counsel being that of the PP's choice, one probably had a reasonable assumption that indeed the PP was making a commitment to assist this inquiry by not bringing somebody new who would start from scratch, given the stage where the inquiry is. And all what was needed, as we're made to understand, as ordinary, who are not in the legal field, that an instruction for the SC to continue cannot be done in any other way other than an attorney. And therefore the brief would have been understood to be as such, but not to restart an inquiry. Now, Chair, this withdrawal, it's probably quite a coincidence that it happens after a thorough going by this committee looking at the charge by charge for 2 days and coming to some draft conclusions on those. And I'm saying draft in the sense that because this committee had also agreed to again give another out to the PP in terms of the draft report. And I'm saying you get that withdrawal at that critical moment. The letter, Chair, does indicate that there is a period, if you look at the letter of the appointment itself. In fact, if I'm not mistaken, it counts about 14 days between that and the appointment. It doesn't mean that in that period the PP was precluded from taking every measure possible to ensure that she gets the legal assistance that she needs, because the resources continue to be there. And for that reason, that's why you still have another attorney that is appointed to still proceed. We have not yet discussed a new budget. It's still the resources that we fought for post the 1st of March. So, Chair, what I'm trying to say, therefore, is that the committee has indeed done everything else to try and assist the process that it remains fair. And as we speak, Chair, a draft report has been sent for the PP to make comments. And as we speak here, similar to the questions that were sent to the PP, there's no comment. And that's the election of the PP not to make comments in that regard. And therefore brings me back to the letter, Chair. We seem at all times to be discussing what an attorney would have accepted as a brief knowingly where the case is, that we are not restarting an inquiry, but the inquiry is at a particular stage. And therefore, as you take this brief, surely you should be knowing what you are entering yourself into, given the time. And you need, therefore, to spring to action and be able to meet the deadlines, because you have voluntarily accepted the brief. So I'm saying, Chair, there's nothing from where one is sitting that talks to unfairness in this regard. Even this draft report, I think the committee, Chair, I must place it on record, has gone too far. In that you have not got response. You put a draft report, but you still say, can you make comments? And we are open-minded that once there is commentary from you, we may reconsider some of the points based on what is made available to us as facts that we can use. And therefore, Chair, anything that is called mitigation, in my view, would have come from responses that get to be put before us. And apply our minds on that. But at this point, there's nothing that has changed from our previous meeting where we adopted the report. And therefore, move, Chair, that the report indeed should be adopted now as a final report of the committee. I thank you.
Thank you, Honorable Maneli. And I recognize Honorable Van Minen.
Thank you very much, Chair. Chair, I really want to agree with the Honourable Milam. I think that what we have seen with this committee is the committee bending over backwards to ensure the rules of natural justice have been followed, that there has been fairness, that the public protector has been given every opportunity to make her representations and to put in her feedback. Unfortunately, we have seen some very long delays with legal representation, up to 4 months. Apparently, there was no time to brief Chane attorneys in that time. And I think one must also bear in mind that when it comes to reasonableness, that it applies to all parties, and the public protector is a qualified individual who has full agency. And it was also important to participate in this process. And unfortunately, we're sitting in a situation now where it is very clear that the public protector has chosen not to exercise her options. And essentially, we have seen a great deal of legal theatre. And at this point, I think the committee has more than done its work in the way that it needs to. And I would support that we table this motion and that it's the report and that it goes to Parliament. Thank you very much.
Thank you, Honorable Van Minen. And I recognize Honorable Sukas.
Good afternoon, Chair. Good afternoon to my colleagues on the platform. Chair, I move in support of the adoption as expressed by other members who spoke before me. There is a reasonable expectation by the public who, through paying their taxes, expects public representatives to act in accordance to what is expected from them in terms of exercising accountability and oversight over the institutions that are that Parliament has oversight over. And a responsible SC and legal team have a duty to conduct their case within reasonable time and cost. These deadlines were known and this time was abused. The context within which this committee functions as an oversight body of Parliament must be recognized and appreciated by both the members serving on it and the public protector in a role as a head of a Chapter 9 institution. The legal team of the public protector should, within that context, have assisted their client to fulfill her constitutional obligation. This committee has gone beyond their own mandate to assist with the legal issues and challenges when funds became limited, and what was received in return is the consistent delays. And within our own obligation, Chair, we cannot, I think Honourable Van Minen alluded to the issue of reasonableness, and there is, we ourselves need to conclude our business within a reasonable time frame, and it would be wrong of us, or it would be, we would fail in our duty to fulfill and conclude matters, and therefore I move for the adoption in support of what was expressed by everyone. Thank you.
Thank you, Honorable Sukas, for your contribution. I now recognize Honorable Majosi.
No, thank you, Chairperson, and good afternoon to all honorable members. I think members have contributed a lot, and I think they've shared the same sentiments. And it's something that we have been sharing for the past, I don't know how many months, and we've been saying one and the same thing, that we can't play with the mandate that we have been given. And as well, these delaying tactics have been there, and they've been delaying us. And I think the whole committee has been fair enough to provide the public protector with every option that was there, and every legal term that was provided. So I think, Chairperson, we just need to now move on and support the report, and also say that we have been in this committee for more than what the duration was given to us. And yes, I agree with other members that we've bent backwards to accommodate the public protector, and I think we've done so fairly, and it is now time to conclude, and we move on and submit, because these delaying tactics are a norm now. We know what is it that we will be expecting when we receive a letter, and so forth. And I mean, we've tried to accommodate the public protector as this committee, and as you as the chairperson, we have also been very, very patient. So yes, I agree with all previous honorable members that let us proceed. Thank you.
Thank you, Honorable Majosi. I now recognize Honorable Mola. I think that's the last hand.
Chairperson, thank you very much. I think 99.9% of the members that spoke before me have covered a lot of ground in terms of the conceptual issues that they've raised with regard to the report and the response of the public protector. One, I think I must remind members and the public that the proceedings of this parliamentary committee have been taken to court for a number of times. So the fairness of the proceeding has been tested to court for a number of times. And all the courts that have had the fairness of the proceedings of this committee have decided or made judgments in favor of the proceedings of this committee. So the doubtfulness and the threats about courts and all that does not move all of us, because we know we've been there before. And fortunately, we have allowed and fairly participated in those proceedings. So I think, Chair, for a fairness point of view, the fairness of this committee has been tested, and the committee remains fair in terms of the decisions of the courts. Chair would have indicated before that this committee has granted the advocate Busisiwe Mkhwebane a number of legal opportunities to help her so that we adhere to the call by the Constitutional Court that she must be legally represented in the committee. But I want to put it on record that it is my firm view that she elected not to use that opportunity given by the committee. Lastly, Chair, would have indicated when we made the draft report that the draft report will be sent to the public protector for her final comments that may be able to assist this committee to arrive even in a different decision. But we further indicated that if she elects not to respond to the draft report, that would mean that she agrees with the contents of the draft report. Now, Chair, I want to second all speakers that have said the draft report must now be a final report of the Parliamentary Committee on Section 194 that must be sent for the decision in the National Assembly. Thank you very much, Chair.
Thank you, Honorable Ngola. I said you're the last one, but I think I now see a new hand. Honorable Zongola, is there any other member that I'm leaving out? Because I wouldn't want to do one by one. Honorable Zongola will be next. Is there any other member, so that I'm not accused of leaving anybody else who has not spoken on the issue? Thank you. I will recognize those last two hands. Honorable Zongola.
Thank you, Chairperson. Mandibulise kubo bonke abantu abakhoyo kulo mhlangano. Chairperson, I want to start by stating ukuba from the very first onset during the start of the process, there has been issues whereby the process was not a process that could be regarded as fair, as a process that could be regarded as above board, particularly for a first of its kind. That is why you recall that part of the court processes that took place in the initial stages of the process was the Constitutional Court ruling that ruled the public protector must be afforded legal representation throughout the process. Now, that on its own shows that if the courts were not approached, there could have been an unfortunate circumstance whereby there is this process, but the public protector would not have been afforded legal representation. So having said that, Chair, the fact that for countless times the courts have been approached on various matters should not make this committee or members of the committee to be defensive. Because if when zinto kakuhle, you have got no problem when people go to court to want to raise some issues, because you know that the courts will rule in your favor. Now, where we are now is that the advocate the public protector, Advocate Mkhwebane, does not have legal representation, and it is not by her doing. It is something that has been ventilated a couple of times, but as we sit here now, that is a known fact. And you'll recall, Chair, that the public protector was still on the stand. There's never been a time whereby you released the public protector so that, after her testimony or after members have...
Sungula has not been attending the inquiry. We have discussed...
Order, Honorable Ngola. I'm not sustaining your point of order. You're disturbing the member on the platform. That's not a point of order. Go ahead, Honorable Zungula.
Nkosi Chair, one defender kule nto anidelelayo. Ndisatsho ke Chair.
Order, Honorable Zungula.
Point of order, Chair.
Order.
Point of order, Chairperson.
No. Just I'm addressing the matter. Asinazo Honorable in a meeting in Parliament. I want you to withdraw that.
Nkosi Chair, mandiyirhoxise. Let me continue. And let me continue because this member is undermining me.
On a point of order, Chair?
Okay, just hold, Honorable Zungula. Honorable Ngola.
Chair, you have just ruled on the matter and Honorable Zungula is still continuing with it. I don't want to go to entertain the issue of Indwana Etelelai because Honorable Zungula knows better than what he's saying, but he's just doing it for public and for vibes.
I check, but you ruled on this matter. Why is Ngola coming back? You ruled.
Yes.
Why is Ngola speaking now, Chair?
He's on the point of order. Thank you, Honorable Maotwe. Honorable Ngola. Are you done, Honorable Ngola?
Yes, Chair, I was saying. Yes, I'm done. I was saying he continues with
He's done. Keep quiet, man. Sit down, Ngola, man.
Maotwe, I have not asked you to speak. Thank you, Honorable Ngola. Thank you. I have intervened on the point of order and unparliamentary language. Honorable Zungula has withdrawn. Honorable Zungula, I want you to continue and please stay focused on your issues.
Yes, Chair. My issue is this member is undermining me because I'm addressing here. He comes and interjects whilst I'm speaking. So as I'm continuing, Chair, is that the public protector is still on the stand. She was never released. That is something that we know. The other issue, Chair, which is very important, is that there are bribery allegations which have not been thoroughly tested and properly ventilated in this forum. There are ongoing investigations that have been confirmed by respective law enforcement agencies. Now, to continue this process, whereas a fellow member of the committee, which made allegations that it was not the public protector or Mr. Kosana.
Just pause, Honorable Zungula. Honorable Ngosi.
My point of order is one of relevance. Two is that this matter was discussed and ruled by this committee, decided by this committee that we do not accede to this thing, etc. Honorable Zungula should go to the minutes, read the minutes. If he wants a review of the minutes, he can then apply for the review of the minutes in another meeting, not this one. Please, Chair.
Thank you, Honorable Ngosi. The point of order is sustained. Honorable Zungula, I've asked you to focus on the issues that are relevant in today's meeting. There's a particular agenda. We are not going to go back on issues that we've really traveled and dealt with. So please, as you go towards concluding, focus on those issues. Thank you.
Chair, I'm focusing on these issues because we're dealing with a draft report. Now, I'm not going to be told or be driven as to what I can comment on or what I should not comment on. I'm going to talk about each and everything pertaining to this process.
So as I continue, just hold. The draft report has no bribery allegation. The draft report is about the inquiry of suspended public protector Busisiwe Mkhwebane. So that's what is in the report. Anything else that is not in that report, I'm going to rule you out not to get into those.
Chairperson, do not seek to micromanage me and confine me to speak.
You're going to operate according to the rules of the meeting. You're not going to be outside of that. Please proceed on your issues on the report.
Yes, that's what I'm doing, Chair, but it is you that is disturbing me. I was proceeding and it is you that is disturbing me. And then you come back and you say I must proceed.
Please go ahead.
So, lastly, Chair, I want to put it out that given what I've just mentioned, this draft report, it is irrational, it is unlawful, it is full of bias. All of these things that I've mentioned, there's no one that can dispute them. That is why we are in this particular situation even now. So as the ATM chair, we want to put it on record that we reject this draft report because it has got nothing to do with Parliament playing its oversight responsibility and upholding the rule of law and establishing a principle in terms of how to hold a head of a Chapter 9 institution accountable. Rather, it is a report that has been drafted with a clear objective from the onset that there is only one outcome that is expected, which is an outcome that will nail Advocate Mkhwebane. We as the ATM view this report as a dangerous precedent for our country because it means the other heads of Chapter 9 institutions, they will not be able to do their work as required by the Constitution because members of Parliament can be bribed to operate in one way or the other in order for them to actually do what should not be done in terms of our public service. So, Chair, we want to put it on record that we as the ATM are not in agreement with this report and will support each and every person that lawfully takes this report on review or this part of the process on review, given the situation. I thank you.
Thank you, Honorable Zungula. Honorable Mangetsi.
Thank you, Chair, and good afternoon to my colleagues and everybody on this platform. Chair, let me welcome today's presentations and briefs that we got. Chair, my take is that I agree with members that are saying, as this committee from the start, we adopted guidelines and we observed them. Colleagues are talking about issues of fairness that has been the cornerstone in everything that we do. Issues of Audi, issues of agreeing that our program was a living document, that each time there was a hiccup, we could accommodate, go back, forth, and make sure that everything else is done within the understanding that we were working with a living document. And as they are saying, Chair, everything else at some stage has to come to an end. The committee has been able to intervene, particularly through you, Chair, on issues of legal costs, which speaks to these other issues, study guidelines that we adopted. Now, it is my also understanding, Chair, that as Honorable Maneli has indicated, that we took numerous resolutions as this committee that we adopted even on the minutes. That speaks to some of issues that are being raised here this afternoon. I remember we spoke at length on issues of the meaning of legal representation, even how the court dealt with it and its meaning in a way. And it has been an understanding, we have never disputed it, that it has been brought to our attention, that PP doesn't have legal representation, but the minutes and our discussion around this matter was centered around the interpretation on what does it mean. And we agreed and we resolved to continue
Hence, we had minutes of how are we moving forward. There has always been an agreement, and we adopted those minutes. Now, Chair, in everything that we did, we took the public along for transparency. It has been an open discussions, it has been open meetings. And that is why even we are here today on this one matter of adopting this report. And we're talking today, discuss some of the correspondence that are here. And I'm agreeing with our members that I say we are here to adopt this report. But probably also, as I agree with them, for if our legal advice is still there, we could just ask them, the interest of the public, is there anything that is preventing us to adopt this report as we are agreeing to adopt it? That will be my submission, Chair. Thanks.
Thank you, Honorable Klape. You would have been the last one. I see there are further hands, Honorable. Is there anything new? Those two hands would have spoken. Honorable Siwela and Lagude. Honorable
thank you, Chairperson. I raised my hand. I wanted to make a point of order during that session, okay. But you ruled.
Yeah, you ruled
it out, so I've got no stage to can stand. I have got no leg to stand upon it. I respect the ruling of the chair.
Thank you, Honorable Lagude.
Thank you, Honorable Chair. Honorable Maneli and Honorable Tlape covered the point that I wanted to embark upon. The issue of, I can add one, that yes, the Constitutional Court ruled that the PP, the suspended PP, has a right to legal representation. But just to indicate that those rights are not absolute. So I don't think we can go back there. And also to say that, Honorable Chairperson, with regard to this very same legal representation, that enough time has been given. Whenever we came across such a situation where there was no legal representation, we allowed for that process to unfold. We paused as a committee. Then with Chane attorneys, I just want to emphasize this point. With Chane attorneys, yes, we received a correspondence that says that Mr. Chane was hospitalized. Again, we paused as a committee. We didn't do anything and allowed him to recover. He came back and they were given 30 days. And in those 30 days, they did nothing other than withdrawing after the 30 days. They were supposed to brief the senior counsel. The senior counsel of the suspended PP's choice, who was there from day one. They were supposed to brief him, but they didn't do that. Instead, they withdraw. So when we talk about fairness, what is it exactly that we are talking about? We've been fair enough. So if there is anything that we did as a committee, then let's see what will happen after we adopt the report. But at this point in time, we cannot go back and not adopt our own report. So, Honorable Chair, I want to agree once more with the sentiments expressed by the other members that we do adopt this report because we have come to the end of our inquiry as this committee. So if there is anything else, we also have rights as Parliament to do. We have the mandate from the House that we embarked on this inquiry. So there is no way that we can go back or delay this any further. We have come to the end of the inquiry. Thank you, Chair.
Thank you, Honorable Dlabode. Honorable members, I now want to summarize your own discussions and what has been placed in front of us in terms of the correspondence. And I want to do that. I see both Honorable Maotwe and Honorable Siwela, you have your hands up.
Chair, after I have summarized, because I've got a problem of network, I want to be the first mover for the adoption of this report. Thank you.
Thank you, Honorable Siwela, for your invitation. Honorable Maotwe?
No, thank you, Chair. I wanted to warn you against allowing what Honorable Dlabode just did, because otherwise we are going to be responding to each other the whole day. I mean, I said things and Ngola came to say things that were completely wrong. There's no court that has found this process to have been fair. He can't come here and say wrong things like that. But if you allow us to speak after they've spoken, we won't finish. Because when they open their mouth and they say something wrong, we are then prompted to speak. I don't understand why she got a second bite, because there's nothing new that she was saying. She said already what she wanted to say, and it's her views. We respect it. We all spoke, but why have a second bite when there's nothing new that you're bringing on the table? So please don't allow that, Chair. Otherwise, we won't finish.
Thank you, Honorable Maotwe, for your intervention and your concerns you're raising. Maybe let me just start in saying, as I try to summarize, honorable members. Firstly, here is a journey of facts in relation to the correspondence that has been placed in front of you, not today, not this week, a number of times. Maybe forget when we have started until the 31st of March, and just start from April and to demonstrate the particular steps that we have taken. Between that time of April and now, we count 143 days. During that time, the Tshwane attorneys would have been on brief for 63 days. Tshwane attorneys would have been on brief for 63 days. And maybe it's not correct, Honorable Dlabode, to say they did nothing, because they did. If there's one thing they were able to do in the 63 days, they did apply for the recusal of the chair. But during that process, so when they withdrew on the 3rd of August, they were on brief for a total amount of 63 days. And then they would have said then, through correspondence and everything, that they were familiarizing themselves with what was in the Dropbox and so on. It became clear at the end, even from them, that at the end of that, they were asking things in the Dropbox and how to go to the Dropbox, demonstrating that the familiarization would not have been in the Dropbox. That's the first point I want to make as part of this journey of facts that we must deal with. And so after that withdrawal from the 3rd of August, it's on the 10th of August, the PPSA gives the suspended PP a list of attorneys per her request, now that an attorney of her choice has withdrawn. And she gets given that on the 10th of August. On the 14th, 15th of August, only then she writes to the state attorney, giving the name of Motswaneng. I'm raising that because you've got to see the sense of urgency and the lack of it in this. Effectively, 12 days later, after the withdrawal of the attorneys. On the 17th of August, just within a matter of a day and a half or 2 days, the state attorneys respond to the positive. In the same way they did when they are appointing Chani. They didn't even take a week or 4 days to do that. And again, I want you to read a sense of urgency and lack of it in how the state attorney conducted themselves in relation to everything else that I want to share with you. Now, Mkhwebane having been appointed, they write to us, because when we meet as the committee on the 11th of August after the draft report has been adopted, I indicated at the beginning that on the same day the draft report was sent to the PP. You now have a situation where on the 20th of August at 6 o'clock that Sunday, Mkhwebane introduces themselves as the new attorneys of choice on brief. Again, I want you to see the sense of urgency and the lack of it as part of that. And amongst other things that they do and they write to us, as explained by Ms. Ibrahim, is to say to this committee, we've now been appointed, we're attorneys of record and of her choice of the suspended public protector. We have not met her. We're likely to meet her latest on the 23rd of August, meaning only tomorrow. So Mkhwebane has not met the PP. They're going to meet the PP tomorrow to try and get the brief from the PP. Again, I want you to look into the sense of urgency and lack of it as part of that. But they go further. This is now the new attorneys. And say, actually, even before we meet with the PP to get particular mandate and so on, was part of the mandate, and then it's en route to the senior council. We already are proposing that we plan that we can give you weekly reports thereafter. There's a timeline of the committee. The timeline of the committee ended yesterday with the PP in terms of her response to the committee. The new attorneys, all they say is that your date of the 21st is illegal. And they still have to be briefed by the PP and familiarize themselves on many other things. So effectively, in summary, what the new attorneys have done under the mandate of the PP, even though it seems that they have not met the PP, they're only meeting the PP tomorrow, they have set new deadlines. They're beginning to set new deadlines for the committee. The deadlines of the committee are going to depend on what they are putting on the table. And in all of that, there's nothing substantive that is being put forward either to respond to the report or as an application of whatever form. And so the point that is being made by members here, that the PP has been given beyond reasonable time, we've been very diligent, we've been very fair and rational, wanting to do things that the response to our fairness and rationality is for this committee to be held to ransom, to be dictated to about how it must do its work to subject a head of the Chapter 9 institution. In other words, the committee must now be subjected to a head of the Chapter 9 institution about what this head of the Chapter 9 institution thinks a program should be. This is what we're getting. If you just summarize what this correspondence is saying. And I therefore hear you members saying that we have been beyond fair. You have given an unprecedented Audi, not once, many a times to the PP. I do want to note the views, very strong views of the EFF that says we must allow the new attorneys to formalize themselves. The ATM supports that, but goes further to say, as far as they are concerned, they want to conclude that this process is irrational, is unlawful, and therefore they reject it, and it's part of their plan to take it on review. The majority of members that have spoken are proposing that we do a final adoption of this report. I'm going to ask, because the report in front of us is titled Draft Report, I'm going to ask that we break for 10 minutes to allow Ms. Ibrahim to fix that. And I'm going to ask members to make an adoption of the report, which is not a draft, as being proposed here, which is a final report, and give time. And then when we come back, that's going to be the exercise that we do in relation to this report, having noted what Honorable Hendricks would have indicated, his own dilemma about issues of HR, which other members have responded to, and what you would have registered before. But the majority of members who have spoken seem to be all in one in saying, let us today adopt the final report. I therefore want to ask that we pause for 10 minutes to allow for that to be placed, and the adoption is an adoption of the final report, not the draft report. Thank you for 10 minutes. We'll be back at 3:45. Thank you.
Recording stopped.
10 minutes that we took a break for. I asked for that break for us to allow Ms. Ibrahim to ensure that in the report we remove sections that deal with the draft report so that we adopt a final report. Before I call on the members for a move and adoption, I'm just going to ask Ms. Ibrahim if she wants to just say something and lead us in that regard.
Thank you, Chairperson. I have removed all references to it being a draft report. However, Chair, there's just 2 or 3 more paragraphs that I would need to add to reflect the outcome of today's meeting. The draft report did not reflect that Chani attorneys had withdrawn, because at the time that it was adopted, that had not yet happened. And also the appointment of Motsuneng Bill attorneys and the letters. So that will just be captured in a very factual manner to indicate the correspondence received and also what the committee decided in terms of proceeding, notwithstanding the objection of Advocate Mkhwebane in that regard. So that will be done. Chair, I just need to check one more thing, please. I've got it clearly articulated that the EFF and ATM reject the report in its entirety, and we'll ensure that that's captured. In fact, it is like that in the draft report. But if we can please check with Honourable Hendricks from Al Jamaa whether they are rejecting the report or only the recommendation in favour of removal. So Honourable Hendricks would have noted that we captured all of his objections that he had raised during deliberation. So where he was of the view that the findings did not sustain a charge of misconduct or incompetence, as it were, that was captured in the draft report. So I just want to get clarity whether it's a rejection of the report in its entirety or only a rejection of the recommendation of the committee to move for removal. Thank you, Chair.
Thank you. I note your hand, Ms. Honorable Mailam. Honorable Hendricks, comment on that?
Yes. It's only the recommendation, so Mrs. Ibrahim is quite correct the way she has seen it. I don't know if she's going to add my comment on the fact that by the appointment of the public protector did not respond, and that I would have called for a lesser penalty, and that I cited mitigating circumstances. Thank you.
Thank you. I think those minority views will be recorded as such. Honorable Mailam.
Chairperson, I just wanted to query whether or not my request at the last meeting has been included or not. And that is that the conduct of Advocate Mpofu be referred to the Legal Practices Council, and that he be criminally charged for threatening you in a committee of Parliament in terms of the Powers and Privileges Act. I'd like to know whether or not that has been included.
Okay, before I go to Ms. Ibrahim, the understanding would have been those are the kind of issues we're going to talk about, so that we want to separate them from the report. We talk about in that session where we concretize the lessons and of the process. But let me check with Ms. Ibrahim.
Noted, Chair. I accept that. Thank you.
Okay. Are you happy with that? So that we don't want it to be part of the report, just to be a separate process. Thank you. Ms. Ibrahim?
Yes, Chair, that's correct. In that separate report, we envisage that there may be a number of recommendations that the committee may wish to make in terms of amendment of legislation or referral of certain matters, whatever the case may be. But that should come after the committee's had time to thoroughly deliberate and consider and discuss those issues. So for now, that is not included. But as I had indicated the last time, this is a permanent committee of the Assembly. It's not an ad hoc committee. Thank you, Chair.
Thank you, Ms. Ibrahim. Honourable members, with that presentation and those amendments, can I now invite members who move for the adoption of this final report? Honourable Dlagude.
Thank you very much, Honourable Chairperson. I move for the adoption of this final report of the Section 194 Committee. Thanks.
Thank you, Honorable Lagude. Honorable Mailam.
Chair, I second the adoption of the report.
Honorable Mailam seconds. Honorable Majosi.
No, thank you, Chair. I was raising my hand to second the report. Thank you.
Thank you. Honorable Majosi supports. Honorable Siwela.
Thank you, Chair. I second.
Honorable Siwela. Honorable Sukas.
Thank you, Chair. I support the report.
Thank you. Honorable Van Minen.
I support the report.
Honorable Dana.
I support the report, Chair.
Honorable Nkosi.
I support the report, Chair.
Thank you. Honorable Maotwe.
Thank you, Chair. We reject the report with the contempt, and we stand by our position that we reserve our right to take it on review.
Thank you, Honorable Maotwe. Rejects the report to take it on review, reserve their right to take it on review. Thank you. Honorable Maneli.
The report is supported, Chair. Support the report.
Thank you. Supports. Thank you, honorable members. The report has been moved for adoption, seconded by a number of members. Honorable Maotwe stands to reject the report, to indicate the positions taken before, and that they reserve their right to take the report on review. With that, honorable members, Honorable Mahau.
We are clear as ATM that you are rejecting the report.
Thank you, Honorable Mahau. As recorded as rejecting the report. Honorable Hendricks did explain himself on where Aljama stands on the report. Any other member before I conclude on this matter? We have the majority decision, we have the dissenting views that have been recorded as part of this. With that, honorable members, Honorable Majosi, is that a new hand?
No, Chair, sorry, it's a legacy hand.
All right. Thank you, honorable members. Therefore, this Section 194 committee has therefore adopted its final report that it will submit to the National Assembly, with a majority of members supporting the removal of the suspended public protector, and having recorded the members who have rejected the report and those who have indicated certain areas of their discomfort, they are so recorded. And therefore, on this report, this is today the final word of the committee on this. This report moves out of the committee. It's now going to be a National Assembly property as soon as we ATC'd it. And therefore, what is outstanding for this committee is we will, in the next few days, indicate to you that they will be doing that exercise, because both Honorable Hendricks would have raised issues in that regard, Honorable Mailam and other members, where we deal with the other issues of further recommendations of what needs to happen within the rules, other institutions, and so on. There is going to be a dedicated day for us to do that. So thank you. We will still thank you. Just to indicate to the report, as the chair, I will add the forward to that report, and the forward does not have to be adopted by the committee. but there will be a forward to the report from the chair as it is submitted. So thank you very much. I want to be, even though we're still going to do it formally, I want to take this opportunity to ask all of you as honorable members, in fact, not to ask, to sincerely thank you in your robustness for being determined and committed to this process, a novel process that was never done before, that you've traveled this journey with us, and you are now in a position to deliver a product to the National Assembly to respond to that mandate of verifying those issues that came out of the independent panel. You have now come to a conclusion of what is it that you sustain or not sustain. It's been a journey with yourself. I'm eternally indebted to you for your patience, your commitment, your guidance, your direction as members of this committee to deal with this novel process. So I want to thank you for your roles. In your own way, you've contributed. As I say, you've been very robust in the manner you have dealt with this. I want to for this moment, thank our entire support staff. And I've always said entire support staff. They include our content advisors, they include our researchers, they include our legal support, they include people who were taking responsibility for transport, they include those who made sure that we have water, drinks and tea, and they include those who would have made sure that we feel safe in the spaces where we have meetings, the protection services of Parliament, and so this is and those who have made sure that when you get into M46, you've got printed copies that the administration under Mr. Ngoma. We thank you, all of you, for the role that you would have played. I want to thank sincerely the role and contribution of our evidence leaders in the role that you have played in therefore demonstrating that we were correct as this committee to design, in terms of our terms of reference, the manner we did to have this expert kind of support. We have learned a lot from the kind of work that we have done, and you have really assisted this committee in its work. We want to thank the members of the media for always being curious and wanting to know about this inquiry, covering it, educating society about it. You yourselves learning from it as you cover it, as you report about it, and as you criticize the process, as you criticize all the role players involved, whether it is the committee and its members, the chairperson, and everybody else. We thank you for your role. Last but not least, as I always do, we want to thank the members of the public, people who are watching us, because what we're doing is your vehicle. This is your work, that we're doing this on your behalf. We've been elected by you to be members of Parliament. We have been very interested from day one up until today. We will indicate, it seems that this committee has generated so much interest. Every sitting of this committee had unprecedented numbers of interest, whether it's on YouTube and so on, from yourselves. We want to thank you. We're still looking forward to your comments as we deal with the lessons and so on. Thank you very much for all of you. Thank you, colleagues. We're now going to leave that and proceed and ask Mr. Ngoma to really just take us through the minutes.
Honorable Chair.
Honorable Maotwe.
Yeah, I'm just saying, on your forward, don't include the fact that you lost 3 conferences, national, province, and region, please.
How can that go to the forward? Thank you, Honorable Maotwe. I won't do it. Okay. Honorable Ngoma. I see Honorable Majosi, you wanted to say something? Honorable Ngoma? Mr. Ngoma?
My hand is not up, Chair.
Okay, thank you. Mr. Ngoma?
Thank you, Chair. Good afternoon once again, and thank you for those kind words that you shared in your summary. And I will make sure they reach all the members of the support staff. Chairperson, when you adopted the minutes of Friday, there's just one set that I omitted, which is the set of 3 April 2023, where we had presentation by the evidence leaders on the evidence before the committee. And I table the minutes as such, Chairperson.
Thank you. Honorable members, there's a set of minutes. Any corrections? None. Do I have a mover for the adoption of the minutes? Honorable Dlakode?
I move, Honorable Chair, for the adoption of the minutes.
Thank you.
Honorable Suele, second.
Honorable Suele, second. Minutes duly adopted.
Chairperson, thank you very much, members. The next Chairperson is the minutes of last Friday with 3 agenda items: tabling of correspondence, consideration of the draft report of the committee, and adoption of minutes. The first 2 pages really attendance, and then I therefore then Chairperson table the minutes.
Thank you. Any corrections, honorable members? None. Do I have a mover for the adoption of the minutes?
Siwela moves for the adoption.
Honorable Suele moves for the adoption. Any seconder?
A second, Chair.
Honorable Milam seconds. Minutes therefore duly adopted.
Chairperson, if you want to, Chairperson, I know this is the part that Ms. Hermans, Chairperson, loves, but just to say that if the committee was ready, the minutes of this meeting are also ready, but we'll leave it for the next meeting. Thank you very much.
Well, unless members want to take a further 5 minutes to read them and then we adopt them, or we can adopt them when we do the lesson sessions. What are members saying?
Honorable Chair.
Honorable Dlakode.
Let's do these last minutes when we do our lesson sessions. Thank you.
Thank you. So we'll hold them back for that day so that we have the final minutes. Thank you, honorable members. I just got on load shedding, so you won't see my face, unfortunately. So that's the last item, honorable members. I want to thank all of you for your contributions. That is where we're going to leave it. The meeting to adopt the final report has now been adjourned. Thank you.
Long live Chairperson.
Recording stopped.
Thank you, Chair.